Number 7. Rajgopal versus State of Tamil Nadu. In 1994, a prisoner had been convicted of murder and wrote an autobiography. He asked a weekly magazine in Madras to publish it, and they decided to go ahead with it. The autobiography had details of the murder and the fact that many senior officials were also involved. The officials, obviously scared, claimed the story to be false and sued the publication for libel and defamation. But the Supreme Court ruled in favor of the media house, stating that public officials can only sue publishing houses if the published material was untrue. This judgment for Rajgopal versus State Government of Tamil Nadu upheld freedom of expression and the right to privacy. Number 6. VISHAKHA and others versus State of Rajasthan. In 1992, Banwari Devi, a social worker, was gang-raped in a village in Rajasthan, only because she tried discouraging a family's efforts to wed their one-year-old daughter. She filed a case and received a lot of support from NGOs. Although their efforts didn't help her cause directly, what they did helped women all over the country. It led to the Supreme Court announcing a prime verdict that helped protect women from sexual harassment at their workplace, which, by extension, also helped establish gender equality. Before 1997, there were no guidelines to deal with such cases at a workplace. As of April 2013, the Sexual Harassment of Women at Workplace Prevention, Prohibition, and Redressal Act 2013 has been established, and the Vishakha guidelines were certainly very crucial in making the new law effective. Number 5. Mathura, the miner who brought about a major change. On the night of 26 March 1972, Mathura, a tribal girl, was called to the police station on account of her brother lodging a complaint against her boyfriend. The officers at the station raped her and then let her go. Mathura decided to file a rape case against the constables. The Supreme Court, however, ruled in favor of the policeman, assuming it was peaceful or consensual, stating that there were no signs of struggle on Mathura's body and that she did not raise any alarm. But Mathura said that they had threatened her into submission. There was a huge public uproar, and the case finally forced an amendment in the Criminal Law Act 1983. The amendment meant that custodial rape was a punishable offense, and the method to deal with consent was henceforth included under India's rape laws. Number 4. Mary Roy versus State of Kerala. Mary Roy, mother of Arundhati Roy, had decided to challenge the Inheritance Act when her father passed away without leaving a will. The Travancore Christian Succession Act 1092 stated that if a man died without leaving a will for his daughter, she would not be entitled to anything. A son, however, would get the property. Mary Roy invoked Article 14 and fought for equality in property rights, not just for herself, but for all Syrian Christian women. The Supreme Court ruled that the Indian Succession Act 1925 be applied to Christians in Travancore and Cochin too. The act recognized equal succession rights for sons and daughters, making it a huge win for Mary and the entire community. Number 3. K.M. Nanavati versus State of Maharashtra. K.M. Nanavati was a naval officer. His wife, Sylvia, had an affair with his friend Prem Ahuja. On 27 April 1959, Sylvia confessed to her husband that she was in love with Ahuja, but he did intend to marry her. Nanavati then dropped his wife and children off at the theater and went to confront Prem Ahuja. He asked him if he was willing to marry Sylvia and take care of the children. He refused, so Nanavati shot him dead and turned himself in. The intriguing story received a lot of media coverage, and the jury was said to have been influenced by it. Nanavati's connections with the influential families were also cited as reasons for the jury to rule in his favor. The case then went to Bombay High Court, where the judge overruled the jury's verdict and found Nanavati guilty of murder and sentenced him to life imprisonment. He was, however, pardoned 3 years later. The case threw light on the fact that a jury could be influenced, thereby abolishing the jury system. Number 2. Shah BANO Begum versus Muhammad Ahmed Khan. Shah BANO was a mother of 5 and age 62 when she was divorced by her husband, Muhammad Ahmed Khan, in 1978. She filed for alimony, which was against Islamic customs. The government thus ruled in favor of her husband. The Supreme Court, however, keeping secularism and the welfare of women in mind, ruled in favor of Shah BANO, thus entitling her to maintenance under Section 125 of the Criminal Procedure Code. This judgment now entitles all ex-Muslim wives to basic maintenance of 3 months from their ex-spouses, post which their care is handed over to their relatives or the WAKF board. Number 1. The Nirbhaya case. On 16th December 2012, a brutal case of gang rape and murder shook the nation. A 23-year-old girl was assaulted and raped in a bus. The criminals then threw her lifeless body onto the road. There were 6 people involved, 5 adults and a juvenile age 17. The adults were sentenced to 10 years in prison, while one of them was found dead in his jail cell during the course of the trial. The juvenile was sent to correctional facility for 3 years. But brutal acts in this case had shocked people beyond belief. There were protests to try him as an adult. This subsequently led to the replacement of our Juvenile Justice Act 2000. The age bar to be tried as an adult was lowered from 18 to 16 years.